All right, good morning, everyone. I'm Judge Jackie Powell, and we're in first appearance court. Today, I'm going to tell you what you've been charged with, and then we'll discuss release conditions, and that's the sole purpose of this hearing this morning. Today is not your trial, so it's not the time when you're going to plead guilty or not guilty or discuss the facts of your case. In fact, I would advise you not to discuss the facts of your case today because everything in this courtroom is being recorded. In the courtroom today, I have a representative from the State Attorney's Office, Attorney Eric Linder. I have an attorney from the Broward County Public Defender's Office, Mr. Brian Reedy. And over at the jail, there is an attorney from the Public Defender's Office at the main jail as well. Also in the courtroom, I have pretrial supervision services representative, I have confinement status representative, and a representative from the clerk's office and or bailiff. So all these people are here to help make these proceedings run a little bit smoothly and to provide necessary information. I'm going to call your name, and when I call you up, I'm going to ask you to come up to the podium, and we will address your case at that time. For those of you who are represented by the Public Defender's Office, the attorneys will assist you this morning, speak on your behalf based on what you've discussed with them. If you have a private attorney, that attorney also, if they're in the courtroom, will speak on your behalf, or if you've already had a conversation with them, when you come up, you can let me know what you wish to do. So at this time, I'm going to start our morning proceedings with Cody Allen Minor.
He's approaching, Judge. He's here at Maine. Come on up, sir.
All right, Mr. Minor, you've been brought before the court for me to let you know that there is an out-of-state hold, no bond hold, and that you will be going to extradition court. Today's Wednesday, so either Thursday or Tuesday. There are Tuesdays and Thursdays, so depending on when they get you on the calendar. Good luck, sir. Michelle Fitzpatrick.
That's North Broward, Your Honor. Good morning.
Good morning, thank you. Ms. Fitzpatrick, good morning. Ma'am, you're before the court for one count of petty theft. It says second offense, and then 2 is a misdemeanor capias, outstanding for an operating without a valid license.
Ms. Fitzpatrick would like to resolve this matter if possible this morning, Your Honor.
Okay. So, Ms. Fitzpatrick, I'm told that you would like to resolve your case today?
Yes.
State, do you have an offer for her?
Time served on each count, Your Honor.
Is that what you'd like to do, Ms. Fitzpatrick?
Yes,
time
please.
served with no further sentence, but you'd have to pay court costs. And we talked about compiling up these valid license charges. You could become an habitual traffic offender and lose your license, right?
Yes.
Okay.
And the same with the petty theft?
Same with the petty theft. If the third petty theft can be charged as a felony. You understand that?
Yes, I do.
Thank you, Judge.
All right,
This
Ms.
is your second.
Fitzpatrick, you want to resolve your case, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I
You
do.
can put your hand down, ma'am. Ma'am, do you understand the proceedings that you're in today?
Yes, I do.
And do you need more time to speak with your attorney?
No, I don't.
Are you under the influence of any drugs or alcohol today?
No, I am not.
Is anyone forcing you to resolve your case?
No.
And do you understand that you do have the right to go to trial, that by taking a plea today, you're giving up that right?
Yes, I do.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you are not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, I do.
What plea do you wish to enter, Ms. Fitzpatrick? Guilty or no contest?
No contest?
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served, and I will give you 6 months to pay your court costs. Ma'am, no return to Publix at 1003 East Commercial Boulevard.
Okay, thank you.
Okay, good luck. Gloria Pantelis. Gloria Pantelis.
Judge, I've been advised medical loan.
Okay. All right, Mr. Shade is here on page 18. It's Robert Casper.
Thank you, Judge. Judge, he also has a, if you see, manufacture and distribute imitation drugs. So it looks like this is probably going to go to the division.
Oh, okay.
So I would just ask that the other matter be allowed to go to the division as well.
All right, is Mr. Casper at the main jail?
Mr. Casper is here at Main, Judge. He's coming up. Come on up, sir.
The amount of the bond, Judge, won't make a difference because he'll have to post 800 on the other, because it won't, 100 regardless on the 750.
Okay.
So, because $75, they don't take that, it's a
Right.
minimum of 100. So the 50 would be fine as well.
Okay. All right, Mr. Casper, you're before the court today for manufacturing or distributing imitation drugs, and 2 is a misdemeanor KPS. You do have, the misdemeanor KPS matter is a municipal ordinance matter, and so Mr. Shade is here to represent you on that matter. And what I'm going to do, I do find probable cause, and what did you say about the bond? $50?
The $50 bond is fine, Judge, on that matter. I'm not
Okay.
for an hour.
And then, Mr. Romero, did you have something to add? Because I'm going to just leave the bonds in place, 750 and 50.
No, nothing to add, Judge.
All right, good luck, sir. Thank you.
Thank you, Judge.
Mr. Shade, do you have anything else?
That's all I have.
Okay. Benna Marie Harris.
I believe Paul Ryan.
Ms. Harris, good morning, ma'am.
Good morning, Your Honor.
You're before the court today for 2 felony capias. It's it's ad charge. Oh, on this one, there are ad charges, but I don't have any probable cause affidavit, no affidavits. So,
What does that mean?
These are, I can provide the court, there's someone not in custody affidavit.
yeah, I didn't even see the first one, if there was a first one.
One moment, Judge.
What does that mean?
I need to review a probable cause, the affidavit of the police officers to determine if there is probable cause to detain you. And so
Okay.
I don't have that as yet. I hear that it's coming to me, so hold on just a minute.
Oh, okay. All right. I'm sorry. Thank you.
No, that's okay. All right, Ms. Harris, I'll recall you in a moment. Just sit tight for a minute, okay?
Thank you, Your Honor.
Samantha Lyanokakis.
North Broward, Your Honor.
Good morning, ma'am.
Good morning.
How do you say your last name?
Leonakis.
Leonakis. Good morning, ma'am. You're before the court for 1 count of grand theft auto, possession of drug paraphernalia, and driving while license suspended, and failure to wear a seatbelt. No, it's manufacture or deliver drugs on count 2. And
Huh?
the
I'm
court.
sorry, can you explain that?
Did somebody speak to Miss?
Yeah, I
Leonakis?
spoke with her, Judge, and I'm not sure I understand the manufacture or deliver aspect of this allegation
Right.
either. I don't think there's probable cause to support that. She did indicate to the officer that she had type 2 diabetes, but I don't see anything in here where she's attempting to sell anything or manufacture anything.
It should just be possession of drug paraphernalia.
Yeah,
Right.
I don't, it's got drug paraphernalia at the
Can I
beginning.
say something,
No,
Your
no,
Honor?
Hold on,
no, just
Samantha.
hold on just a moment. It's got paraphernalia at the beginning and the end, but I don't know. So it's supposed to be just drug paraphernalia? Because that's all
Yes.
that it is.
Yes, ma'am.
All right, so I find probable cause for grand theft auto, possession of drug paraphernalia, driving while license suspended, and then the failure to wear seatbelt is not from magistrate. Does the parties wish to be heard as to the bond?
Judge, I'm going to be asking for an ROR from Ms. Lionakis. I believe that the vehicle involved is her ex-boyfriend's vehicle, and there might be an issue down the road as to whether or not she had permission to operate the vehicle. She has been living in Florida since she's 6 years old. She's been living in the same location for the last 30 years. Unfortunately, she has a, thank you very much, Virginia. Unfortunately, she has a disability that prevents her from working or saving money to post any kind of monetary bond. So I would ask the court for an ROR at this time.
I would note there's nothing here indicating that there was permission to use. The vehicle was reported stolen the same day that she was found in the vehicle.
I'm aware that it's not in the probable cause affidavit.
Then it's-
That doesn't mean it's not true.
But then-
And, you know, when things come out and the details come out down the road, I think that that may be very well the type of situation that we're looking at, Judge.
Yeah, well,
Your Honor, and as I know the court's aware, factually speaking, that's what's to be considered, what's before the court. Anything, Ms. Leonakis can allege anything can be alleged. Other than what's factually before the court, then it's the other factors that are to be considered, her ties to the community, financial resources, and so on and so forth.
I understand that, Mr. Linder. What is her priors?
DWS 2015, 2 counts of domestic violence battery, 2013, resisting without violence 07.
All right. I will put, I'll be inclined to put Ms. Leonakis on standard pretrial release. All
That would
right?
be fine, Judge.
So I find probable cause, and I'll release her to standard pretrial release supervision.
Thank
Good
you,
luck,
Judge.
ma'am.
You'll be getting out. You'll be getting out in a few hours, Samantha.
Okay, thank
You have to
you.
report the pretrial release within 24 hours of your release.
What does that exactly mean?
So, all right, we can go back to Benna Marie Harris. Where is she?
All right.
There's a Paul Ryan.
Excuse me.
All right.
Excuse me.
All right, Ms. Harris, you're before the court today. It's 2 additional charges for dealing in stolen property and grand theft of a motor vehicle. And I do find probable cause based on the affidavit and the supplemental report that's been presented to me. Does the parties wish to be heard? Well, there is bonds imposed.
Yes, Your Honor. Just so you know, Ms. Harris, this allegedly occurred back on August 21st of 2018. A vehicle supposedly belonging to Russell Foote. Don't say anything about the facts of the case. Judge, on counts 1 through 3, Ms. Harris is already on pretrial release. She appeared before Judge Duffy yesterday, and her pretrial release was reinstated because the notice had been sent to the wrong address. She's currently attending Bible college, studying for her bachelor's in psychology. And I would ask the court, since she's on pretrial release for counts 1 through 3, I'd ask you to put her on pretrial release on counts 4 and 5 as well.
All right, so I will grant, is it standard? Do we know if there are any conditions?
That I do not know.
Okay. All right. It's standard, thank you. So then I'll release Ms. Harris's standard pretrial release. Good luck, ma'am.
Thank you, Your Honor. Thank you.
You're welcome. Tresca Burnham. Tresca Michelle Burnham.
Judge, I've been informed she bonded.
Thank you. Elizabeth Dobbins.
North Broward, I believe, Judge.
Elizabeth Dobbins.
Medical
That's
reset.
North Broward. She's a medical reset. I let them know.
Thank you.
You're welcome.
Ruth Neal Daniels.
All right, Your Honor.
Good morning.
Good morning, ma'am. You're before the court today for 4 counts of felony VOP pretrial violations, and then count 5 is a burglary of an unoccupied dwelling unarmed. I do find probable cause as to count 5. All the other counts are not from magistrate.
Yes, Judge, she's on pretrial release for those other charges. I'd ask the court to consider placing her on pretrial release for count 5 as well.
Wait, is she still on pretrial release?
I
on
think
that?
so. That's what she told me.
Well, she
Yeah,
was
revoked.
ROR'd on
but
the,
it was revoked.
is it revoked in
Yes.
ROR?
Yes.
Maybe
Can I call?
pretrial can help us out with that.
Yeah?
As I'm able to talk,
Hold on just 1 second, Ms. Daniels.
Your Honor,
Okay.
I'm going to be requesting a $1,500 bond on count 5. As you can see, she's out on 3 separate felonies, one of which is a burglary of a dwelling.
For which apparently she's been ROR'd. Is that what I'm understanding happened here?
4th.
So Judge Porth felt it was not necessary to impose any monetary bond at all.
This case
I'd
is-
ask the court to consider pretrial release for Ms. Daniels.
Your Honor, I'm sorry to be talking. When I spoke to my pretrial officer, when she called me and she would let me know aware of this, she said that I will be R&R'd on all my charges since I've been doing so good. And 3 of my charges had got dismissed from Judge Force, but I don't know if it's still showing. She was like, all my stuff would be R&R, but on the last one, I don't see that. But I've been compliant and doing everything I'm supposed to do.
Well, Your Honor, if we're basing this on what Judge Porth thinks is a good idea, then we shouldn't put her on pretrial because if he thought pretrial was good for her, he wouldn't have signed the warrant to revoke it.
Well, then I'd ask the court to ROR her since Judge Porth felt that was appropriate.
Yes.
Wasn't asked to set a bond on the new charge.
Don't say anything at this point, Ms. Daniels. She has been living here all of her life. She's lived the last 15 years with her father. She collects child support. That's her main source of income because she does have a disability. She has 5 children, ages 25 to 3. The youngest children are currently in the custody and care of her 25-year-old.
If you look at the warrant.
I have the warrants.
I've never seen that, so I just want.
All right,
Yeah, that was the third. This violation is her third violation of pretrial.
I don't know what happened in the other case. I don't know what was presented, but what yes. No, I have the paperwork. But I'm gonna impose a bond of $1,000 on count 5.
I'll call your family for you, Ms. Daniels,
Okay. Thank you.
Michael Dwayne Rich.
All right, Your Honor.
Thank you.
Good morning.
Mr. Rich, good
would like to
morning.
resolve this, Judge.
Good morning, Judge.
You're before the court for a misdemeanor KPS on a suspended driver's license. I do find probable cause. Your attorney tells me that you wish to resolve the case. State.
Yes, ma'am.
1 moment, Judge.
Judge, just FYI for the court, Mr. Rich has been in custody since June 18th, 2018. The habeas was issued on the same day that he got arrested, on June 18th, 2018.
All right,
He
so,
will be released, sentence complete, and his payment.
okay.
The offers of withholding court costs. It also looks like he was arrested at 9:45 at night, so I imagine the KPS already occurred.
Okay, Mr. Rich, the offer to resolve the case is a withhold adjudication and court costs. Do you wish to resolve your case with that?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
I do, yes, ma'am.
Okay, sir, please put your hand down. Do you understand the proceedings that you're in today?
Yes, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
And do you understand that you have a right to go to trial, that by taking a plea today, you're giving up that right?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter, Mr. Rich? Guilty or no
Guilty.
contest?
No contest.
All right, sir, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is a withhold adjudication and court costs. I'll give you 6 months to pay your court costs, sir. Good luck.
Thank you, ma'am.
All right. Charles Holmes.
He's approaching, Judge. Oh, Judge, he declined the service as a public defender.
Okay.
Judge is going to talk to you, sir.
Mr. Holmes?
Yes, ma'am.
Sir, you're before the court today. There are 2 misdemeanor KPS outstanding, and then the 4, 5, and 6 are traffic KPS. What that means is that on all those cases, you failed to appear in court, and so a warrant was issued for your arrest. You are entitled to representation, so the attorney from the public defender's office is there if you wish to use their services. What do you?
Ma'am.
Do you wish to have an attorney represent you at this time?
I mean, for what cases? Because I have an attorney already where I was supposed to appear in court last week on the 1st, and I thought it was the 11th. So I'm trying to see what case is for.
All right, so again, you have 2 misdemeanor KPS. You were supposed to be in court, and you didn't appear, and for DUI and DUI enhanced, and then there are some traffic infractions. So what I'm gonna do?
And that's who I have, Attorney William Chong for.
All right, so I find probable cause, and then tomorrow you have court. So I believe if your attorney knows that you're going to be in your division, he'll be there to represent you on these cases.
All right, thank you, ma'am.
All right, sir, good luck. All right, we're going Go.
Mr. Santiago is here present. Main judge approaching.
Mr. Santiago, you're in court today for a misdemeanor capias matter. It's operating without valid license that you failed to appear in court. I do find probable cause. What does Mr. Santiago wish to do?
Judge, from what Mr. Santiago advised me, he basically has a clean record, so he does not wish to resolve it. He did advise me that he got notice for this court date after the fact. My understanding, Judge, he's been here his whole entire life. He lives in Fort Lauderdale. I don't know if the court would consider an ROR on his behalf. If not, he did give me the phone number of his family, who I intend on calling right after court to post his bond.
All right. I'll ROR Mr. Santiago. Good luck,
Thank
sir.
you, Judge.
Wellington Gomez.
Judge,
We're
we're trying to determine whether or not we need a Portuguese interpreter for Mr. Gomez, Judge. If
Okay.
we do,
You want a Portuguese interpreter, or do you want to proceed? It's up to you.
I can proceed.
You want to proceed?
Yeah.
okay, because it'll be
Judge,
10:30 before
Mr.
the Portuguese interpreter should be here.
Well, if you guys were having problems, I know we're gonna go down this rabbit trail, so.
I don't know. I'm not over there, so I can't tell you. Do we need a Portuguese interpreter?
He's ready to proceed, Judge.
All right, Mr. Gomez, you're before the court today for 1 count of driving while license suspended, 2, operate a motor vehicle without license, and 3, failure to register motor vehicle. All right, I do find probable cause, sir. What does the parties wish to say about bond?
Judge, I understand it's a driving while license suspended $100 bond. My understanding is being Mr. Gomez. He's been here for 16 years. I believe he may have one traffic from Palm Beach in 2011. Judge, I'm going to be asking if the court would consider an ROR on Mr. Gomez's behalf. If not, I'd ask the court to sign a property order so he can have access to his property so that he can try and bond.
All right, I'm not gonna ROR. I will, the bond is $100. I will sign that order. Good luck, sir.
Thank you, Judge.
Robert Lee Gross.
Going proud, Your Honor.
Good morning, sir. You're before the court for a misdemeanor capias on a petty theft matter. You failed to appear in court on February 5th, and the court does find probable cause. What does Mr. Gross wish to do?
Judge, he self-surrendered, and he indicated to me that his bond should have been posted by now. Maybe if we could check on that.
All right. Do we know if Mr. Gross's bond has been posted? All right, it's not showing that it's been posted yet, so the bond is $1,500. Good luck, sir. Davion Anthony Ridge.
Medical loan, Judge.
Medical loan. Alexander Polanski.
Here at Main Judge, Municipal Ordinance.
All right, I'll leave this, Mr. Polanski, I'll recall your case, okay?
Sir, you're...
Maurice Guadalupe.
He bonded, Judge.
Brian Trala.
He's approaching, Judge. He's coming. He was in the back. Mr. Charles here, present, Judge, at Maine.
Mr. Trolla, you're before the court today for, it's 2 misdemeanor KPS on account of resisting without violence and disorderly conduct. And the court does find probable cause.
Judge, in speaking with Mr. Trolla, he wishes to ask the court if the court will consider resolving these matters today.
All right, State, do you have an offer for Mr. Trolla?
The documented offer from the assigned ASA is adjudication time served.
All right, Mr. Trolla, if you want to resolve your case today, the offer is adjudication time served. Do you wish to resolve your case, sir?
Yes, ma'am.
All right, Mr. Trolla, please raise your right hand. Do you swear or affirm to tell the truth?
Yeah.
You can put your hand down. Do you understand the proceedings that you're in today, sir?
Yes.
And do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of alcohol or drugs?
No.
Do you understand that you have a right to go to trial, that by taking a plea, you're giving up that right?
Yes.
Have you ever been treated for a mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Trolla? Guilty or no contest?
No contest.
I accept your no contest plea, and I find that it's freely and voluntarily given. I sentence you to adjudication and time served on both counts. Good luck, sir.
Thank you, Your Honor.
Isaiah Lamar Thomas.
Paul Ryan, I believe, Judge.
Isaiah Thomas.
He should be here in about 2 minutes, Your Honor.
All right, I'll recall it. Thank you.
Okay, Your Honor.
Juan Barquero.
Judge, he's here present. My understanding is he has private counsel, Mr. Eric Clayman. I believe he's on his way.
That is correct. I spoke with Mr. Clayman. He is
All
on
right,
his
then
way.
we'll recall when Mr. Clayman is here. Thank you.
Thank you, Judge.
Lazar Hayes.
Mr. Hayes is here present. Judge, he's approaching. Come on up, sir.
Mr. Hayes, good morning. You're before the court today for its 2 additional counts. Count 4, dealing in stolen property, and count 5, false owner info for pawned items. And the court does find probable cause as the parties wish to be heard as to bond.
Judge, Mr. Hayes advised me that he's been in custody since this Saturday, but he's being held on a $8,500 bond, and I believe he has an out-of-county hold for child support. He advised me he's not in a position to post anything close to what he's currently being held on, let alone these new charges. So I'd ask you to take that into account, determining a reasonable release condition. But one thing Mr. Haynes did want to know, I did advise him the new additional charge are dealing stolen property and false ownership. He has no clue where this stems from or when it was. Judge, can you tell me when was the alleged date of incident and what city this allegedly took place in?
1/30/2019 from 110 East Broward Boulevard.
And, Your Honor, I'm going to request that the court keep the bonds in place. The $8,500 worth of bond that Mr. Hayes is being held on is for charges of strong arm robbery and battery. He was already out for introduction of contraband into the detention facility and possession of cocaine when he got arrested for those new offenses. He also has additional history, including but not limited to false ownership info on a pawn item from 2017, where he was sentenced to 364 days county jail.
All right, the court does find probable cause. Mr. Hayes' bond on count 4 and 5 are $3,500 each. Good luck, sir. Keyshawn Demps. Keyshawn Demps.
One moment, Judge. He might be in the restroom. Judge, can we put him on recall? I believe he's in the restroom.
All right, we'll do. Jonathan Taylor.
Mr. Mr. Taylor, come on up, please.
Mr. Taylor, you're before the court today for account 1 is a misdemeanor capias, and 2, 3, 4, and 5 are felony capias. My notes indicate that you should be in division FH for your felony matters tomorrow at 8:30, and then on the misdemeanor matter, February 15th at 9 a.m. I will leave the bond in place for $500, and counts 2 through 5 are not for magistrate, no bond hold. Good luck, sir. Clifford Strong.
Strong, come on up, sir. He's approaching, Judge.
Mr. Strong, you're before the court today for 1, illegal use of a credit card to obtain goods, 2, fraudulent use or possession of an ID of another person without consent, 3 is larceny of a credit card, and 4 is illegal use of credit card.
Conviction for anything? Ever been diagnosed with a mental problem?
More than 2 times in 6 months to obtain goods. The court does find probable cause. What does the parties wish to be heard?
Judge, I do understand the bonds that are currently in place is $2,000. And speaking, Mr. Strong, he did advise me that he cannot afford it, and no one's going to be able to afford to post this bond. So, Judge, we're going to be asking the court to consider releasing Mr. Strong on pre-trial release. He's 29. He's been here his whole entire life. He's working. He works for a company called A&J Spray Cleaning, where he's been there employed for 5 years, making $13.50 an hour. Right now, Judge, he is living in Margate with his girlfriend and his girlfriend's parents. His girlfriend is pregnant. No, I'm sorry. She gave birth, and their child is 17 months old. She's not working. He's supporting her and their child. Judge, I do realize that he has a record, but he's been clean from what he advised me for a couple of years now. Judge, he did assure me that he will be coming back to court, so we're asking the court to consider releasing Mr. Strong on standard pretrial release.
Your Honor, I'm requesting that the bonds be kept in place.
Mr. Ferguson?
This is ongoing criminal activity against the same alleged victim. His criminal history, 2012, strong-arm robbery while wearing a mask and battery against a victim over the age of 65. He was sentenced to 28.5 months in Florida State Prison. 2008, grand theft of a firearm and dealing with stolen property. He violated probation. I would also note that apparently this is a crime committed against someone who he was residing with for a number of years.
Judge, as you heard from the state, he went to prison. He got out in 2014. From what it seems like, since it's been 5 years since he's been with no sort of contact with the criminal justice system. So, Judge, right now he is supporting his family, so I'm asking at this time to consider releasing Mr. Strong on supervision.
All right, the court does find probable cause, and I am going to leave the bonds in place. Count 2, $1,000. Count 4, $1,000. And count 3, $500. Good luck, sir. Mark Conan.
Your Honor, I understand he's represented by Jim Lewis, and I left a message from Mr. Lewis, and I'll try him again.
All right.
But I haven't heard back.
All right, we'll see if we hear from Mr. Lewis. James Jackson, we'll recall Mr. Conan.
Mr. Jackson's here.
Mr. Jackson, you're before the court today for one count of possession of cocaine and two is a municipal ordinance violation. The court does find probable cause. As the parties wish to be heard as the bond.
Judge, I'm going to be requesting pretrial release. I'll see if state has an objection before I proceed.
I do.
Judge, Mr. Jackson did advise me right now he is on disability. That's his only form of income. He's 58 years old, been living here in our community for over 35 years. He lives in Miami. His rent is approximately $215 per month. Tells me he has priors. I believe, though, the last time he was in trouble was about a year ago. So, Judge, considering this is a non-violent offense, I'm asking the court to consider releasing Mr. Jackson on pretrial release.
Okay, Your Honor, his Broward history, 2013, possession of cocaine, 2013, resisting without violence, carrying concealed weapon, resisting without violence, 2012, theft, 2012, possession of cocaine, 2012, possession of cocaine, 3 times in 2010, sentenced to state prison, another possession of cocaine, 08, state prison, possession of cocaine with intent, 08, state prison, aggravated assault, a deadly weapon, and felony battery, great bodily harm, 06, a year and a day state prison as a habitual offender, possession of cocaine, 06, dealing with stolen property, 98, 7-year state prison. This history goes on from there, Your Honor. I checked. It appears every time Mr. Jackson has been put on probation, he has violated his probation. I see numerous occasions where he was taken into custody on court orders for committing new law offenses while already out on charges. My concern is, even on pretrial, as he's shown in his history, he is unable to follow release conditions set by the court.
Judge, one correct information which Mr. Jackson informed me, and I made an incorrect statement. I said the last time he's been in trouble was 1 year ago. It's actually been since 2007. So he's basically, since 2017, been clean, Judge. So I'm asking on this nonviolent offense pretrial.
All right, I'm going to order a standard pretrial release supervision. There'll be random testing. Mr. Jackson, you need to report to pretrial release within 24 hours of your release. Failure to do so will result in your arrest. Good luck, sir.
Your Honor, it's Paul Ryan. I have Thomas here.
Right, count one. Right. What was that on Paul Ryan?
Thomas here, right? He's here.
All right, who do we have? Thomas? Isaiah Thomas?
Yes, Your Honor.
All right. Mr. Thomas, you're before the court today for some additional charges. Count 5 is grand theft. Count 6, fraudulent utter use of a false instrument. 7 and 8 are violation of probations, which are no bond holds. I do find probable cause as to 5 and 6. Your bonds on those are $1,000 each. And you should be in Division FF tomorrow at 8:30 on the violation of probation matters. Good luck, sir.
What's FF?
That's the division, the felony division that you're in. All right. Are we ready on the, well, we're waiting for private attorneys on.
We can go on Barquero.
Barquero, Juan Barquero.
Good morning, Your Honor. How are you?
Good morning,
Nice
Mr. Clayman.
Eric Clayman on Mr. Barquero's behalf.
Nice to
Thanks, sorry for being slightly late.
No problem. All right, Mr. Barquero is before the court today. It's additional charges. So count 4, attempted felony murder, and count 5 is aggravated assault with intent to commit a felony.
Correct.
And the court does find probable cause.
Just I have one brief argument just before you make your finding, which
Sure.
prior to, as I understand it, before I got involved in Mr. Barquero's case, another judge found the proof evident presumption great. I do have an argument for that, and it's fairly brief. Under the statute for an attempted felony murder under 782-051, it could be charged under sub 1 or sub 2. Sub 1 is if one of the predicate offenses is an enumerated offense, it's then a first PBL. If it's not an enumerated offense, at that point, it's actually simply a first-degree felony, which is what my argument is here. The ag assault with a firearm or the ag assault to commit a felony, for lack of a better term, is not one of the enumerated crimes in the subsection. So I do believe, and will concede at this point, that there's PC for it under subsection 2, but not as filed under subsection 1, which would hold him no bond, making it a PBL as opposed to just a first-degree felony.
Okay.
And Your Honor, I believe what the finding was for over the weekend, it should be attempted murder, first degree, Your Honor, and I believe the allegations support a finding for attempted murder. His actions were premeditated. Certainly there was intent based on the numerous shots fired. Frankly, the only reason we're before the court today is the detective did not include additional counts for the second victim, which is mentioned in the report, Your Honor. Judge Hilal did find proof evident or presumption great for attempted murder for one of the alleged victims, set a $10,000 bond for the aggravated assault. I'm going to ask the court to make the same findings and impose the same bond and same bonds.
All right. I do find probable cause, and I also will make a further finding of proof evident presumption great. That, of course, is a preliminary decision.
Sure, I understand.
So Mr. Barquero, on count 4 will be held no bond, and then on count 5, I will impose the $10,000.
Your Honor, just so I have a proper list, because it seems to keep changing, can you just read out for me the counts as you have it, 1 through 5?
I don't have all 5.
You don't have
I
all
only
5.
get what's to be before the court
I
today.
understand.
So I only have 4 and 5.
Got it. Okay, very good. All right, I appreciate that, Judge. And then
I'll go over with Mr. Klayman.
Thanks, Mr. Linder. And I'll handle the rest of the division. Judge, thanks for your time.
You're welcome, sir.
And
good to see you.
You as well. And I'd also just, on behalf of Mr. Barquero, because I don't know if it was done in the past, we would invoke his rights at this point.
Sure.
Have a great morning, Ron.
You too.
Juan, hang tight.
All right, good luck.
And Judge, whenever the court's ready, I know you have Mr. Keyshawn Demps on recall. So whenever the court's ready to proceed, we're ready on it, Mr.
All right,
Demps.
we can proceed with Mr. Demps.
Mr. Demps, come on up, please.
Mr. Demps here before the court today for 1 count of grand theft auto, and counts 2 through 7 are felony VOP pretrial violations, which are not for magistrates. So as to count 1, the court does find probable cause, and your bond is $8,000. Good luck, sir.
Judge,
yes.
Mr. Demps is going to be asking for the court to consider releasing him on pretrial release. So that's the defense's request on count 1.
That'll be denied. Thank you. Quinton Nelson.
He's approaching.
Mr. Nelson, good morning. You're before the court for 1 count of possession of heroin. And the court does find probable cause as the parties wish to be heard as to his bond.
No, Judge.
Oh. All right, then your bond, sir, is $1,000. Did I miss someone on page 16?
Yes, Your Honor.
I'm sorry, I didn't realize that you were before Mr. Klayman.
No worries. It's page 16, Victor Mendez.
Okay.
North Broward.
Yes. And my name is Lila Sayende on his behalf, Judge. I read the piece. Huh? Just Mendez. I represent Mr. Mendez. I did read the PC, Your Honor. It looks like it doesn't exactly dictate who held the gun at the victim. I'd just be asking for a bond for Mr. Mendez. I don't believe he has any priors. His family is going to be watching him like a hawk. Asking for a $50,000 bond with a monitor for the court to feel that, you know, he will be where he's supposed to be, put him on house arrest, and allow him to bond out today.
All right.
And Your Honor, I'm going to be seeking a no bond hold on the armed burglary. While it doesn't really matter which co-defendant was in possession of the firearm. They both are culpable for the offense as principals. The evidence would seem to indicate that Mr. Mendez was in possession of the firearm. Well, when he was apprehended, the firearm was found in the same proximity where he was located by the dumpster. He admitted to stealing the firearm out of a brown van. He admitted, and then it mentions, he admitted when the witness yelled out to him, he was the one who had the gun. He admitted that he pulled it out, the firearm, released the magazine, and racked it. I'm also concerned, it's mentioned, I'm concerned about Mr. Mendez being released at this point based on his statement at the show up that you guys should wear masks because someone could go after your families.
All right. I do find probable cause, and
No.
Your Honor, may I
No,
speak?
no, you may not speak. Do not speak.
all right. As to count one, is count two. All right, as to count one, I will impose a bond of $10,000. On count two, will be a no bond hold. Count three is $100. Count four is going to be $500.
In Your Honor, I imagine for record purposes, the court is finding proof evident or presumption great on
Yeah,
count two.
I'm getting to that.
Oh, sorry.
No, that's okay. As to count two, I find proof evident, presumption great. Of course, this finding is a preliminary finding without prejudice. And there shall be no contact with the victims in this case. So count one, 10,000. Count two, no bond. Count three, 100, and count four, $500. Good luck.
Okay, thank you, Your Honor.
You're welcome. And I did write it.
I'm free to go.
I know. Amari Prince.
Is that it? That's it.
Is there a main judge?
Mr. Prince, good morning. Sir, you're before the court today for one count of possession of cannabis, 20 grams or less. Counts 2 and 3 are felony violation of probation. Count 2 does, the violation of probation on count 2 does have a bond of $1,000. Count 3 is a no bond hold, so count 1, I'll leave the bonds in place, 100, 1,000, and then count 3 is a no bond. And you should be before your felony judge tomorrow at 8:30. Good luck, sir. DeAndre Lamont Bellim.
He's approaching Judge Main.
Mr. Bellim, you're before the court today for one count of operating without a valid driver's license. Counts 2 and 3 are felony kepious matters. Count 4 is a misuse of temporary tag. And count 5 is a disobeying stop sign not for magistrate. The court does find probable cause. No bond is required on count 1. Counts 2 and 3 are no bond holds not for magistrate. Count 4 does have a bond of $100. Count 5 is also not for magistrate. Good luck, sir. Tyler Mahinsk.
He's approaching Judge here at Maine.
Good morning, sir. You're before the court for one count of a burglar for structure or conveyance armed, and the court does find probable cause.
And again, Your Honor, the state would be seeking a finding of proof evident or presumption grade for first appearance purposes only under a principal theory of the crime.
Right. I do find probable cause, and I'm further going to find proof evident presumption great, and Mr. Mainsk will be held no bond, and that finding is, of course, without prejudice. Good luck, sir.
Just ask for no victim contact.
And no victim contact in this case.
Thank you, Judge.
Giancarlo Lescano. Okay,
Mr. Lescano, bonded, Judge?
thank you. Denroy Ferguson.
Mr. Ferguson is here present, Judge at Maine.
Mr. Ferguson here before the court for one count of grand theft. And the court does find probable cause as the parties wish to be heard.
Judge, I'm going to be asking the court to consider releasing him straight ROR. He's 26 years old, been living here in South Florida since 1999. He's working at Applebee's. He's been there for 1 year. He's the flat top cook there, making about $10 an hour. He lives in Tamarack, there where he's renting a room, and his rent is going to be $700 per month. So, Judge, considering this a nonviolent offense, I'm asking the court to consider a straight ROR.
Based on the allegations, I'd have no objection to pretrial.
Yes. I do find probable cause, and I will release Mr. Ferguson to standard pretrial supervision. Mr. Ferguson, you need to report to the pretrial services within 24 hours of your arrest, or your release, and failure to do so will lead to an arrest. Michael Shinshamir.
He's here present, Judge Maine.
Sir, you're before the court for one count of possession of burglary tools with intent to use, and 2 is loitering or prowling. And the court does find probable cause.
Judge, I would argue that there is no probable cause to support count 1 based on the probable cause affidavit. It appears Mr. Shinsheimer, taking the evidence in the light most favorable to the state, was seen looking into cars. I don't believe there's any allegation that any attempt to break into a car was ever observed by anyone. So perhaps there's loitering and prowling. But as far as possession of burglary tools with the intent to use, he is found in possession of a mask and gloves and a wrench. and the officer comes to the conclusion that these items are typically used in the commission of burglaries, but there is no burglary here. To say that just because Mr. Shinsheimer was in possession of these items does not mean that he intended to commit a burglary at all. There's no probable cause to support that contention.
Well, Your Honor, Mr. Reedy stated himself he was seen looking into windows of cars. Based on that, I think that there is ample evidence of his intent, considering he was in possession of a plastic mask, several pairs of gloves, and a wrench.
Looking into cars is not a crime. And to take the leap that because Mr. Shinsheimer was looking into cars that he intended to use these tools in the commission of a burglary, there's simply no evidence to support that.
Right, I do find probable cause. What does the parties say to bond?
Judge, I'm going to be asking the court to consider releasing Mr. Shamer on pretrial release. Right now, unfortunately, he's looking for work. He's not employed. He's homeless. He's financially indigent. He does have a mailing address that he could use of his aunt who resides in Hollywood to get future court notices. So he would be coming back to court because he would have an address to get notices. Judge, he's 32 years old, but at this time he has no sort of property, no money in the bank. So we're going to be asking the court to consider releasing him on pretrial release.
Your Honor, I would object to pretrial. He just got ROR'd on January 29th for a false fire alarm. When he was arrested originally on that offense, he was out on a burglary of a conveyance that he was ordered to be held no bond. Now, the state dropped that charge. He also has a trespass from last year, so he keeps getting into trouble.
All right, I will release Mr. Shinsheimer to pretrial release. Sir, you need to report to pretrial release within 24 hours of your release. Otherwise, you will be arrested. Good luck, sir. Emmanuel Adeoye.
He's approaching, Judge.
Sir, how do you say your last name? Adoy.
Yes, ma'am.
Sir, you're before the court today to let you know that there's one count of violation of parole. You should be going before the parole board shortly. Good luck, sir. Jeffrey McPherson.
Mr. McPherson, come on up, please.
Mr. McPherson, you're before the court today for one count of assault on an officer, 2, battery on an officer, 3, resisting officer with violence, 4, resisting without violence, and 5 is trespass. And the court does find probable cause as to all those counts. Does the parties wish to be heard?
Your Honor, one moment. Your Honor, I'm going to be requesting a $1,500 bond on count 2, a $1,000 bond on count 3, that all the other bonds be kept in place. His criminal history, 2016, out of the state of South Carolina, assault and battery. It looks like 2015, assault on a law enforcement officer, malicious injury to property, and disorderly conduct. Burglary in the 3rd degree, 2014. Assault and battery, 2014. Another assault in the mid-90s. I'm showing failures to appear both out of South Carolina and Hawaii. Nothing further, Judge.
Judge, right now, Mr. McPherson is homeless. Unfortunately, he doesn't have a mailing address. He's 7 years old. He's been clean for 3 years now without any contact with the criminal justice system. Judge, I'm asking for a release.
Right, the court does find probable cause. As to count 1, the bond is $100. On count 2, it's $1,000. Count 3 is $1,000. Count 4, $100, and count 5, $25. Good luck, sir. Michael Shapiro.
Mr. Shapiro is approaching, Judge. Come on up, sir.
Mr. Shapiro, you're before the court today for 1 count of obtaining a vehicle by false representation, 2, fraudulent use or possession ID of another person without consent, and 3, passing a forged, altered bill or promisor's note. And the court does find probable causes to all 3 counts. Do the parties wish to be heard as to what? You're saying he's on pretrial. He's currently on pretrial, that he was placed on pretrial last August.
CF10A and 164514 CF10A. He was on pretrial supervision with, on a standard supervision. Actually, that was then changed. He's actually on electronic monitoring. Based on this court's finding of probable cause, we act on his pretrial status. We were both at this time in both his open cases.
Your Honor, on the new charges, I'm going to be requesting bonds in the amount of $7,500 each. Frankly, the allegations in this case, these are the type of allegations that make up Mr. Shapiro's criminal history. As you can see, the 2 cases he's out on, one for two counts of grand theft, 2 counts of uttering a forged instrument. The other for grand theft and 4 counts of uttering a forged instrument. In 2011, he was convicted of grand theft auto, sentenced to 35.5 months state prison as a habitual offender. 09, uttering a forged instrument and grand theft, 35.5 months state prison as a habitual offender. 01, grand theft, 5 years. 93, grand theft, check fraud, forgery, 10 years state prison as a habitual offender. It goes on from there, same type of offenses, and I imagine the court is familiar with the allegations in this case. It's the same type of fraud, deceit, making up false statements, false allegations to the victim, to law enforcement, claiming he's in Orlando when in fact he's in South Florida, using fake checks or fraudulent checks.
Judge, and speaking, Mr. Shapiro, as the court heard, he's been on pretrial, I believe, level 2 since August. This is the first time he's, from what he advised me, that he's violated his pretrial. Judge, he's currently residing at First Step. He's been, this court is a lot older than August, since he's been on pretrial. He said he's been attending all his court dates. He's 60 years old. We're asking the court to consider releasing him on level 2 pretrial as well on these new law offenses.
Your Honor, if I may add, it is true that he was living at a facility. We were contacted by the program. Apparently, for whatever reason, they had to go and get into his room, and they found information belonging to other residents. It's currently being investigated, so he has been terminated.
All right. As to the pretrial supervision that Mr. Shapiro has been on case number 159406 CF10A, I am going to revoke his pretrial supervision, and there will be no bond. As to case number 164514 CF10A, I am revoking his pretrial supervision, and he will be held no bond. There is great concern for the community in these new allegations, and as to count one on the new arrest, count one, the bond will be $10,000. Count two, it'll be $10,000, and count three, it'll be $1,000. Good luck, sir. Maines Bunnett.
Your Honor, that's North Broward. He's a medical reset.
All right.
Your Honor, I was just asking.
This has been, go ahead.
I'm sorry, I was just going to see if the court can make a PC determination.
All right.
I reviewed the probable cause affidavit. I don't have a problem with that.
All right, I will find
Would like him
probable.
brought back for bond.
Sure.
All right, the court does find probable cause. It's the possession of cocaine and drug paraphernalia. This has been the third reset, so we'll bring him back for a bond. Michael Catania.
Conti, Your Honor. Your Honor, he's again in courtroom 5750. And the paperwork says he's got court again tomorrow.
This is what's going to happen unless we, I don't know, Brian, if you want to have a bond set, or I don't know.
I don't know what's going on in his division, so they might be doing that right now.
Well, no, and my understanding from
It's a
confinement
change of charge.
And my understanding, Your Honor, even if we set a bond today, if his judge sets a bond, and I'm just seeing who that is.
Yeah, we don't want to have conflicting.
No, they go, the jail gives deference to the assigned judge.
The division
If-
judge?
Sheila, is that correct, that if Judge Kohler sets a bond, and we set a bond, the jail will go with what Judge Kohler says, since that's the assigned judge?
The problem is, it's difficult for me to argue for a bond when I haven't had a chance to speak to the gentleman. I mean, I don't know anything about his ties to the community or any other mitigating factors that the court might wish to consider in setting an appropriate bond for him, so.
I don't know how to reset it. He's got court tomorrow and then the court next day, so I can find probable cause and we can bring him back for a bond.
I don't mind the court finding probable cause. It's that maybe we can bring him back on Friday.
It's not about resetting, we're gonna be in the same situation every day. If he gets reset here in Acapias, the clerk is automatically gonna set him for court the next day, and it's gonna be in this continuous loop.
It's true.
I understand, Mr. Linder. I think we have to figure out how to deal with these because they come up every week, so.
Exactly.
I'll make a note of that.
If you wanna set him for the afternoon?
Yeah, but then sometimes by the time they transport him back or something.
I know.
So, let's figure out how, I'll try to figure out how to deal with that, but at this time I'll find probable cause and then, we can work on getting him back for a bond.
I'll look into it, Judge, and see what happened in his division.
All right, thank you. Devin Atkins.
I believe he's a medical loan.
He's gotta come back for a bond, determination. Devin Atkins.
I believe he's a medical loan, Judge.
He's on medical loan, okay.
Yes. According to.
And then Calvin Atterbury.
He's here present at Maine, Judge.
Yes, ma'am.
Mr. Atterbury, you're before the court today for grand theft. And the court does find probable cause.
Sure, so that's what I wanted to ask. Mr. Atterbury was in, and I don't have a system in front of me. He believed he was here in front of the court in front of for a felony petty theft. I don't know if it's a grand theft or a felony petty theft.
It looks like a felony petty theft.
It's a felony theft.
On which one? The one that's before us today?
Yes, I believe so.
My paperwork says grand theft. And
I don't see an amount mentioned in the
And
probable
that's
cause
what I was going
affidavit,
to
so
say.
that would not support the charge of grand theft of more than $10,000.
Yeah, he's not.
the Walmart, the merchandise, $193.32.
Okay. Yeah, and you're on your booking sheet and your PC affidavit should both be felony theft.
Well, my booking sheet says petty theft, third or subsequent offense,
Right.
which is probably why it should be a felony petty theft. And the dollar amount that I have is a $193.32. I didn't see any other dollar amount.
And the officer on the PC charged with felony petty theft.
All right, so I will make a finding for felony petty theft. Felony petty theft. All right, so a fine probable cause for felony petty theft. Does the parties wish to be
Judge, having said that, I believe a standard bond on felony petty theft would be $750, but regardless, Mr. Atterbury informed me he can't afford to post a monetary bond. He's 58, been here his whole entire life. He works when he can for a labor pool. Judge, whenever he works at a labor pool, wages fluctuate. He can get anywhere from like $50 to $80 per day. He lives in Fort Lauderdale with his sister. His sister advised me she's working. She's a caretaker, but she deals primarily with all the expenses as far as the bills, so she's not in a position to post a bond. So Mr. Atterbury is requesting court releasing him on pretrial release.
Your Honor, I can advise the court. Mr. Atterbury in 2016 had a felony theft. He was sentenced to 2 years in state prison on January 5th of 2017. In 2009, he was convicted of burglary with damage to a structure or dwelling over $1,000 and grand theft, sentenced to 92 months in state prison as a habitual offender. In 2009, grand theft auto, fleeing and eluding, 92 months state prison as a habitual offender. 2009, burglary of a structure, same sentence. 2004, burglary of a structure and grand theft, 67 months state prison as a habitual offender. It just goes on from there, Your Honor. Multiple burglaries of dwellings, structures, 10-year prison sentence, a 12-year prison sentence.
All right, I find probable cause, and I will release Mr. Atterbury to standard pretrial supervision. Sir, you need to report to pretrial within 24 hours of your release. Failure to do so will lead to your arrest. Good luck, sir.
Good luck.
All right, we were Alexander Polonsky.
He's approaching, Judge.
All right, sir, you're before the court today for a municipal ordinance violation. You failed to appear in court on October 22nd, 2018, so a capias was issued.
Your Honor, let me explain, please. I tried to go that month and next month to clerks of courts on the second floor. Both months they said it's not in the system, not in the system. So I just thought they didn't put it in the system, and I forgot about it. I said, let me pay the fine. They said, no, you should first go in front of the judge. But I went first month when it happened, and the second month I tried to check it.
All right, well, the only problem here at RR, Mr. Polonsky, sir, there was a capias issued by another judge for your failure to appear. But here's and now my notes show that you should be in court tomorrow at 9:30. Division MP is which judge? I'm sorry, Judge Levy.
If I have to, I will appear, of course. I simply didn't get any mail, no notification.
I don't know if you'll be released in time to get to court tomorrow for 9:30.
Whichever.
Right, the charge, the charge is an alcoholic beverage violation.
Yeah.
I'm gonna dismiss this charge. Okay? Good luck, Mr. Polanski. The case is dismissed.
Thank you. Goodbye.
What do I write on the, yes, G? You'll do it? Okay. Do you need me to still sign it? There's no attorney from the city, no attorney, Mark Conan.
Mr. Conan's here, Judge.
Well,
Leaving
we were
messages
waiting
for
for his
Mr.
attorney, right?
Lewis. I haven't heard back from Mr. Lewis, Judge.
Madam, can I proceed with the public defender? Because I haven't talked to Mr. Lewis in over a year, so.
Oh.
I'll go with the public defender first, and
Okay.
I'm sorry.
No, that's okay. Sir, you're before the court today for 1 count of possession of cocaine, 2, possession of drug paraphernalia, and 3, attaching registration license plate not assigned. And the court does find probable cause. What does the parties wish to be? Does the parties wish to be heard as to the bond?
Yes, Judge. Mr. Conan is not going to be able to afford to post the $1,000 bond, nor, unfortunately, his mother that he lives with. He's 57, been here his whole entire life. He is working. He's basically supporting him and his mother. He works for a demolition company and making about $12 an hour. Now, they do live in Plantation and been living at the same house for about 36 years. His mom is on Social Security. She's 87 years old and depends on Mr. Conan for her basically everyday activities, things of that nature. From what Mr. Conan advised me, with her limited financial resources, she's not going to be able to afford to post a monetary bond. So, Judge, I'm going to be asking the court to consider releasing Mr. Conan on standard pretrial release. And I do see here this is a drug offense, so we wouldn't object if the court also wanted to impose an additional condition as far as random drug testing.
Just so the court's aware, Mr. Conan has a lengthy history involving drugs, drug possession.
Right, I will release, the court, I do find probable cause. I'll release Mr. Conan to pretrial release with random testing. Sir, you need to report within 24 hours of your arrest, of your release. Failure to do so will lead to an arrest. Good luck, sir.
Thank you. Thank you, Your Honor.
You're welcome, sir. All right, I have no other PCs before me, so I take that we're to the end of our docket. Thank you, everyone.
All right, thank you, Judge.